Jabari Zakiya is an expert on supervised release, a system that is being used by the prison industrial complex to keep people on the plantation. Is it unimaginable to think that a person receives a sentence, serves it out, only to be released on supervised release and serve more time than his or her original sentence? Jabari Zakiya brings this truth to reality. All right, as we unpack this, we need to first establish not so much as the problem with supervised release, but what is supervised release?
Well, supervised release was created in 1984 with the Sentencing Reform Act of 1994 in the middle of the Reagan year. And two things came out of that act. The first thing was the creation of the Federal Sentencing Commission. And the other major thing was the abolishment of the use of parole and probation in the federal system. They replaced that with this thing called supervised release. So supervised release is an extra sentence that gets put on to people's prison term, and it only becomes effective after you have fully served your prison term. And then when you get out, then they say you're on this thing they call supervised release.
All right, and so supervised release came through the Reagan administration, and are we talking about specifically D.C. code offenders, or are we talking about nationwide? Anybody that's under federal jurisdiction?
Any federal conviction, any federal sentence from a federal conviction since November 1st, 1987, that's when supervised release became effective. That's when federal courts start to impose the sentences that included supervised release. So yes, D.C., anywhere across the country.
Okay. So now, for the benefit of our audience, because we just don't want to assume that everybody got an understanding of the sentencing mechanism in the prison industrial complex. So walk our audience through the sentencing mechanism. So you have, once a person is convicted, walk them through it and to the whole process. You can use yourself as an example.
Okay. So currently, for federal convictions, once you get convicted of a federal crime, you have a sentencing hearing in front of a federal judge. At the sentencing hearing, the judge imposes the sentence, which concludes a prison term, could include a prison term,
right.
Could include other provisions, but usually in the case that we're talking about, it includes a prison term of so many years or months, and then a term of supervised release that follows the prison term. Now, supervised release is not mandatory for the widest sets of categories of crimes. Statutorily, supervised release only has to be imposed by statute on a certain category of crimes, such as terrorism, child molestation, etc. All other categories of crimes, or all other categories of people that get convicted of crimes, it is discretion. It's at the discretion of the court whether to impose or not a term of supervised release. But by practice, they dole out supervised release like jelly beans.
Okay.
So, but most people don't know that. Most criminal defense attorneys don't act like they know that, and most public defenders don't act like they know that because they don't challenge during the sentencing hearing, why are you giving this person a term of supervised release? What is the basis of it? What is the legal basis of it? Why are you giving them a certain time period? What is the legal basis of why you giving somebody a 3-year term of supervised release? Like in my case, I had a 16-month prison sentence and a 3-year term of supervised release. Well, why is the term of supervised release almost twice as long as the prison sentence? I didn't know anything about that at the time. My public defender didn't do anything to contest it. So the system keeps rolling along by practice, through inertia. Everybody just lets it go, and very few people challenge it. The good thing is people are starting to challenge it.
Okay, so let's talk about this here. All right. I get convicted of a crime. I got 16. The penalty for the crime, the maximum penalty for the crime is 24 months. That's the maximum time I can get for the crime. I can only get 24 months for the crime. That's it. So you can give me 24 months, you can give me 1 year sentence, and then you give me 1 year probation. But it can't go beyond 2 years in my sentence. So now under this guideline of supervised release, I can get, is that term of supervised release a part of the penalty? Would my sentence be 24 months plus 3 years supervised release? Would that be when I look at the statute or what's the sentence for this crime I committed, would it say and supervised release or?
So and this is one of the greatest problems. The prison sentence is the punishment.
Right.
Okay, when you talked about the 24 months, that's your prison sentence. Supervised release is this unconstitutional second sentence, because supervised release allows the government to put you back in prison without the benefit of having to convict you of any crimes. In fact, all the people who go back for revocations of conditions of supervised release, those are for non-criminal activities. Those are for what is called administrative technical violations, such as dirty urines, such as being in the presence of other felons, like your cousin or your mother or your brother.
Or nobody you might not even know it could be a felon.
Or for not getting a job within a certain period. Or for merely not calling back your probation officer or meeting with them at a certain time. These are technical violations. They are totally unconstitutional because essentially there's no place in the Constitution that allows the government to supervise people after they have completed their prison term. The prison term is their punishment under the Fifth Amendment.
So, okay, let's go now. Now we got to understand supervised release. Recently, as of May the 6th, the ACLU filed a suit against the government claiming supervised release and parole status set people with disabilities up for failure. All right. And in this suit that they filed, the ACLU, the Public Defender Department, and a few other legal organizations filed, they were basically saying under the supervised release, it doesn't take into account a person's disability or mental state. But more importantly, in the suit, and we look at the body of the suit, they suing parole and probation, they suing parole, and they suing the Office of Supervision, which is known as CSOSA, all right, which is the mechanism or the institution that deal with supervision.
In D.C.
In D.C.
Right. District of Columbia.
All right. But in the suit, it talks about the way they go about assessing once a person is put on supervised release, the way these entities that's responsible for the supervision, the way they make a determination on how you're going to be supervised, they use a metric.
Right.
And in the metric in turn say, okay, this person should have drug tests, this person should have meet twice a week with their PO, this person should have a job in 30 days, this person should have a place to stay or be in an identifiable shelter. Because all these things that I'm putting in this mechanism, if you don't do these things, those are the things that's going to lead to a technical violation.
Right.
Right? How did that play out? Now, they saying that in this lawsuit, they saying that this mechanism doesn't take into account circumstances. It's arbitrary, capricious, and too general. And what they saying specifically as it relates to people with disabilities and mental health. Is that the case with across the board?
Right. What they're dealing with are obvious, egregious collateral damage from the whole structure of supervised release.
Come on.
Right. So when they abolished parole and probation in the federal system, they claim in the creation of supervised release that the purpose of supervised release was for rehabilitation. So, and it was supposed to give people a way to transition back into coming out of prison into society, and that this was supposed to help people. which is the exact opposite of what its actuality is. The practice of it is it's just another means to control and punish people after they have already served their full prison sentence. So what the ACLU is finally doing, because in 2019, when we created the Coalition to End Supervised Release, we actually met with the DC Probation Office, Public Defender's Office, and the Federal Public Defender's Office, who deals with the federal cases on the side. The DC deals with the DC cases. So what they're doing is attacking the collateral mechanism. They're not attacking the legality of the system. All right. What I'm saying is, it's an analogy would be, say you could either say slavery is bad, or you could say and unconstitutional, or you could say certain conditions under slavery are bad.
Right.
Oh, well, you shouldn't be able to just to rape people, arbitrarily. You shouldn't be able to cut people's feet off. You shouldn't be able to beat people. But slavery is all right.
Right.
But just don't make it so onerous that you violate, make it so ugly and heinous that these things occur. That's kind of the approach they're taking. When anybody who has their rights restricted is unconstitutional because you've already served your prison sentence. So they've created this facade, and the courts have gone along with it, and most organizations go along because you have to attack the full fundamental principle of the idea that once you have served the prison sentence, that is your punishment, period. There is no other means for the government to have any kind of supervisory or administrative authority over you. Because you have served your prison sentence, you are a free person. You can do what you want. The government has no authority. The Constitution doesn't give the government any authority to supervise anybody. It only says they can punish people for a crime whereof they have been duly convicted.
And okay, let's examine the whole application of supervised release. All right, so you say under certain crimes, it's only certain crimes can be given. A person can be given.
Are mandated. Yes.
Are mandated. So, and that's in the law.
That's in the
law. But outside that, it's discretionary.
It's totally discretionary.
All right, and when it's mandated. It's mandated. They pass a law to say it's mandated.
It's by statute.
Okay.
The statute 18 U.S.C. 3583 lists the categories of offenses where the courts are mandated to impose a term of supervised release. Every other thing is discretionary. All
right. So now, in terms of where the disconnect comes in at, it comes in at when it's being done arbitrary and capricious, or is it a disconnect in the sense that it should never be in existence?
It should never be in existence.
Why?
Because the government has no constitutional authority to supervise. You're an American citizen. You're supposed to be an American citizen. So when you are convicted of a crime, the prison sentence is the one punishment under the Fifth Amendment that they can impose upon you, period. You do your 5 years, 10 years, whatever that prescribed sentence is for that particular offense, that's it. You come out, okay, I've done my time, I've served my sentence, I am now a full and functional citizen, presuming that you were a full and functional citizen in the beginning. But that's it. So when you had probation and parole, what happens is you get a 10-year sentence. You come up for parole after 30% of your sentence, or let's just say 3 years. So because there's nothing in the Constitution that says you have to go to prison. It says punishment. So under the former system before they created supervised release, you had a 10-year sentence. You come up for parole after 3 years. The government can decide how to punish you. They can say, well, we'll keep you in prison, or we can allow you to serve the remaining 7 years of that 10-year sentence after you come up for parole in 3 years. You can serve that outside of prison, but you're still under administrative control of the court, which is your parole officer. So if you violate whatever conditions that were part of your parole supervision administrative plan, then you can go back. But you only have one sentence. And after that 10 years is over, that's it.
So they send you back, even though, like, say you say, like, just like you say you got 60 months, 5 years, you do 40 months. they let you go out on parole, all right, and you got 2 years left on your sentence. You violate, they send you back. You got a year left on your 60 months. At the end of the year,
that's it.
That's it.
That's
okay,
it.
But under supervised release,
you
right,
serve your whole sentence.
They gave you.
They give you 5 years, you serve your whole sentence. Then the day you walk out of prison, your term of supervised release starts.
Oh, okay, I see the problem there. So now you really, they didn't give you an extra sentence.
They gave you an extra sentence, but this time they can put you back in prison for non-criminal offense.
Right. And to your term of supervised release, or they can keep nitpicking you. Like in the case of the people they sued, they send them back for a year, they're gonna let them go. They send them back for another year. They can keep doing that back and forth. But under the traditional system, they can send you back and say mandatory out, say like, just bring it to the door.
And so many people under the conditions of parole and probation, you don't have to go. You can max out in prison if you choose.
Right.
And many people did or chose to do that because, especially if you have a shortened sentence, because they didn't want to go through the hassle of being ping pong from halfway houses back and and try to find a job and stuff, and then getting caught up. So many people would say, no, I'm gonna just max out. So then when they left, it's like, goodbye, see you later. You don't have no control over me at all.
Right.
Under this system, you do your max time, they can ping pong you back for, like I say, all these little trivial so-called administrative violations that are not crimes. And the whole point of this system, those white guys, those white males in the middle of the Reagan administration, with the complicity of the Democrats, put this in place with that explicit purpose. Because Reagan came in 1980, he became president in 1981. We had gone through the Vietnam War, we had gone through the Vietnam protests, the student riots, the Civil Rights Commission. At the beginning of the Reagan administration, the federal prison population was somewhere around 20,000 people. 20,000 people total across the nation in the federal prison. After he left, that population rose from 20,000 up between 80 and 100,000. So the whole purpose of one of the whole purposes of his administration was those rabid Confederate white racists said, you know what? We can't allow these people to go out and protest these policies, to confront the government. And so we need to put more of them in prison. And of course, they did the mandatory minimums, they did the crack cocaine deference. All that was designed was to put particularly black people, black males in prison, and to keep a revolving door to keep them in prison.
Why you think so? Why, okay, if it's so draconian, supervised release is so draconian, and it applies nationwide, why do you think you don't have more kickback nationwide about it? Because because according to your argument, it's unconstitutional. It's not mandated by law. It's discretionary under certain circumstances.
Right.
But yet it's being practiced all across the board. Why you think we don't have no more opposition to it in terms of like trying to get it reversed?
That's a very good question. Part of it is just inertia. People just go along with the system. But the arguments I've just told you, they are being made, and they have always been made from day one. Unfortunately, the groups that should have been the natural people to argue these things from the beginning, like the NAACP, Urban League, ACLU, they were asleep at the wheel. And even again, a lot of these laws were passed with the complicity of Democrats too.
Right.
It wasn't just Republicans, and it wasn't just Reagan. They existed under Clinton. Clinton made it worse. Obama didn't do anything about it, right? So it's not just a one party kind of thing. It's a total acceptance by both the Republican and Democratic Party that we need to put more, particularly black men in prison and keep them there for as long as possible. And the courts have basically rubber stamped it because they haven't really done the serious analysis that is now being forced upon them by the ACLU that should have been done in 1987 when these sentences started to be put down.
I mean, this is what they say in the quote ACLU. There are just absolutely no policies or procedures to assess their accommodation needs or to provide the accommodations that people need just to have an equal shot at completing supervision and staying in their community. Now here, you preference this with, they're talking about people with disabilities.
Right.
Right? But could you apply that across the board? There's no provisions being provided for people in general?
There is the government has no authority to supervise anybody.
Right.
If they wanted to provide a system for harmonious and stress-free reintegration back into the community post-prison, they could do that. They could absolutely do that, but it wouldn't have nothing to do with punishing people and sending them back to prison. It would just be a transitional period that has nothing to do with reincarceration. They could do that, but they don't want to do that. They have to create a means to put people back in prison. They'd rather put people back in prison than actually help people transition, because then that whole mindset, that group of these rabid right-wing racist white men don't want black people, don't want brown people being able to walk the streets and be full citizens and compete ideologically, financially, and every other way with their whole whiteness dominating. You know, that's this whole thing with these white people now. They are scared out of their wits that they are a declining minority in this brownification of the United States. And they want full and complete control of everything. And they know they don't have the numbers. Their numbers are dwindling. And so these mechanisms are being put up. That's why all across the country, in Florida and all these people, they want to say, you can't read these books. They want to call anything black people do black extreme organizations, which has no constitutional meaning whatsoever, and et cetera, et cetera. This is an ongoing war. Most black people don't understand that this is a war. This is an overt war that these white males are continuing because they never in their mind thought they lost the Civil War. Right.
So let's as we look at the supervised release, right, going forward. So what were some of the things what was some of the work that y'all did, and how far did y'all get in terms of like trying to get it dismantled?
Okay, one thing that most people don't know, and your attorneys won't tell you, the judge won't tell you, is that there is a statute, part of the statute under supervised release. After a year on supervised release, you can petition your sentencing court, your sentencing judge, to terminate the remaining part of your supervised release. So one of the things we did, I used that provision, and I helped get one person's 3-year term of supervised release terminated after 18 months. Okay, right. This is in the statute. This is a right that everybody on supervised release has. You can just file a motion after a year, say, please terminate the rest of my term of supervised release. Usually the probation officers won't tell you, your offense attorney won't. This should be just structurally streamlined. It's like, okay, you're up, like with the probation part. After a year, you should go back and automatically go back in front of the judge and say, I want to terminate the rest of the but they don't do it that way because they don't even tell you that you have a statutory right to request this.
And if people want to try to get it reversed or try to get in the advocacy space of getting it removed altogether, what is your recommendation?
Well,
if that was something that was feasible.
Well, there's two ways to attack this systematically. You can attack it through the courts, which is what the ACLU, but ultimately you have to attack it through legislation. Because the appellate courts and the Supreme Court have shown no inkling of abolishing the whole system, even though, as you noted, you can cite all these collateral unconstitutional consequences of its, mechanical imposition, right? There's no way to impose a system constitutionally.
Right.
There's no way to do it. So they don't even try.
Right, right.
So it's like slavery. Either you abolish it or you keep it going, right? So you got more cases from the Supreme Court upholding slavery than you do abolishing it, right?
Right.
At some point, you just have to build enough momentum where enough people finally say it's wrong.
Right. All right. So now let's look at as we get ready to close. Let's look at the impact this has on families.
Right. Well, like you say, a common condition of supervised release is you can't interact with other felons. So if everybody in your family was convicted on a case, so if you go to a summer barbecue and your brother's there or your cousin in there and they were convicted on the same count or whatever, you could be in technically a violation of your supervised release.
And in terms of like from your own personal experience and your knowledge, how often do they violate people for like just nonsensical stuff?
Unfortunately, actually, they have studies by the Sentencing Commission that actually documents this. But what we know absolutely that in the current federal prison population, somewhere around 30 to 35% of the people in federal prison, are there for revocations of supervised release, not for convictions of new crimes.
And so that means 30% of the population that they send back. So and from your knowledge, is this a continuum? Do they keep this number fluid? Like I'm gonna make sure I got this ability to keep this population back to a number by 30%. I know that I got, in addition to like people being on parole, I know they subject to violate. I got probation, they subject, but now I got a sure thing in supervised release because I can nitpick. Right. From your knowledge, is this something that you see as a common practice?
It's a common practice. You can get the numbers from the actual Bureau of Prisons because they list that. The Sentencing Commission comes out with their yearly reports. So yes, this number is known. That's why I can say it's between 30 and 35%. And they can tell you what are the types of offenses people are getting revoked from, right? So what I'm saying is that everybody who goes to prison has a number.
Right.
Everybody goes to prison has a term of imprisonment. So all that information is empirical. It's not random. You could go by every person they put and you can compile why you're here, how long you're here, et cetera, et cetera. So what they don't want to do though is show you that the whole purpose of the system is not rehabilitation. Because here's the constitutional argument. If they claim a prison sentence is your punishment, then how can putting you back in prison for revocation of a technical violation be rehabilitative when it's the same actual remedy for two supposedly different things, right? So how can prison be a punishment under one condition and a rehabilitation under another condition? It doesn't make any sense.
No, it doesn't.
And that's the whole thing. People have to be engaged in extreme acts of cognitive dissonance to justify how doing the same thing, putting people in prison, has two totally separate and opposite purposes.
All right, as we close out, what do you want people to know and what are you advising them in terms of like trying to get this?
Okay, here's what people really, here's functioning what people need to know. If people who are about to be put into have a federal trial, and 85% of the people or more in the federal system plea bargain. They don't even go to trial. So you just cop to a plea. Again, you need to you need to know that supervised release is discretionary. And you need to first know, is the offense that I am convicted of or pleading to, does that have a mandatory term of supervised release?
Right.
If the answer is no, then when you go to sentencing, you need to make your attorney contest the requirement or any discretion to impose a term of supervised release because they're supposed to explain why, under their discretion, they think you deserve a certain and what the length of that term is. So you need to contest that at sentencing, because if you don't contest it at sentencing, you can't use it as an appeal, right? And so systematically, all these people need to understand, contest your whole sentence. Contest it, contest it, contest it. Also, you need to know, again, after a year on supervision, you can petition to have the rest of it terminated.
Okay.
So these are the mechanical things people need to understand, because if people just started exercising your statutory rights, you could really make a dent in the reincarceration of people.
Okay. Thank you, Jabari.
Okay.
There you have it, the real news. Rattling the bars. Jabari just rattling the bars about supervised release. It's unconstitutional. It's draconian. It extends a person's stay in prison. It's supposed to go from punishment to rehabilitation, but the only thing it's doing is rehabilitation according to the definitions to restore you back to your rights. So basically what it's doing is putting you back in prison. That's what it's restoring you to, put you back in prison. We ask that you continue to support the real news and Rattling the Bars. We ask that you look at this information that we just brought you about supervised release. If you have a family member or somebody you know that's on supervised release or getting ready to get convicted of a sentence or getting ready to plead, then take Jabari's advice. Have them look into whether or not their sentence or the crime they committed mandate supervised release, and have them, if it don't, have them contested. Have them be aware that if they do get supervised release, after a year they can appeal to have it revoked, or they can have their probation terminated. There you have it, the real news. And guess what? We are the real news.
Thank you so much for watching the Real News Network, where we lift up the voices, stories, and struggles that you care about most. And we need your help to keep doing this work. So please, tap your screen now, subscribe, and donate to the Real News Network. Solidarity forever.